Welcome to the INREM podcast, where we discuss the law for real estate investors. Andy and Sean are both attorneys. Nothing said in this discussion should be considered legal advice. We're simply providing information and education. You should consult with an attorney in your state regarding any specific legal issue that you may have. Good morning, everybody. Today, our topic is estate planning for real estate investors. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to follow us and like our channel. You can find us on Facebook. You can find us on YouTube. YouTube is our primary venue. Go there at INREM Podcast. That's at INREM Podcast. You can go subscribe, click the like button. We would appreciate it greatly. With that, we're going to go to Sean, who has our legal update.
Thanks, Andy. So our legal update today is what is a security agreement and when is it used? So there's a lot of confusion regarding security agreements. So I'll be talking to investors or others about using a security agreement, and they'll say, well, what's a security agreement? What does that even mean? And so the explanation is basically a security agreement is a document used to create a lien against personal property. So when we talk, for example, real estate or real property, there's two types of documents that we use to create liens against real estate. The first is a mortgage. So in states where mortgages are used, you would have the owner of the real estate sign a mortgage, and then you would record the mortgage. And in states where deeds of trust are used, like here in Arizona, you would have a deed of trust. That's the second document to create a lien against real estate. And the owner of the property would execute a deed of trust, and you would record the deed of trust, and that would create a lien. A security agreement is a document similar to a mortgage and deed of trust, but instead of creating a lien against real estate, it creates a lien against personal property, both tangible and intangible personal property. So if I am a lender and I provide a car loan and I want to make sure that I have a lien against that car loan. So in order for me to place a lien against that car loan or have a lien against that car loan, the owner of the car has to execute a security agreement in favor of me, the lender. And then I would take the certificate of title and hold it, or I would have myself as the lender endorsed on the certificate of title for the vehicle. And that's how I perfect my lien against the vehicle. But the security agreement is what allows me to have my name as a lender on title, or allows me to hold the title documents for the vehicle until such time as the loan is paid off. So the security agreement creates that right and that right to the lien. You also can secure a lien created by a security agreement through the filing of what's called a UCC-1 financing statement. So it's a one-page document, doesn't even have to be signed by the borrower or the owner of the property. And it can then be filed with the Secretary of State of the state where the property is located. So you file that with the Secretary of State, and that then gives notice to the world of the fact that you have this lien against that property. But you can't go and just file a UCC-1 financing statement without having a security agreement that basically says, yes, you can have a lien against this personal property of mine and record a UCC-1 financing statement. So where we see security agreements used the most is to basically create a lien against business assets. So if I own a business and I am going to sell the assets of my business to a third party, a buyer, and the buyer says, hey, can you carry back some of the financing? Can you be the lender? Say, sure, I'll be the lender. So you're going to give me a note, and instead of a deed of trust or mortgage like you would in real estate, you're going to give me a note and a security agreement. And the note will say, what the principal balance is, what the interest rate is, what the monthly payment is, or how that amount's going to be repaid to me as the seller of the business and now the lender. And then the security agreement is going to reference the note and say, hey, this note was given to this lender or this seller of the business. And if you don't perform, the seller of the business or now lender has a lien against the assets of the business and can come back in and basically take those assets or take over the business again or take back the business. And so they have a lien against it. And then once those documents are signed, I will go and file with the Secretary of State a UCC-1 financing statement saying, hey, look, world, anybody that's coming after me, any other creditor, anybody that wants to do business with this new business owner, be aware that I have a lien against the assets. And if the new business owner doesn't pay my loan as agreed, I can come in and take over those assets. So that is a security agreement. It's used to create a lien against personal property. And it's a very similar document to a deed of trust or mortgage, which are used to create liens against real estate.
I found that oftentimes where clients are confused is, when is it personal property? And really property is just divvied up into two categories for individuals, right? There's real property. And if it isn't real property, it's personal property at the end of the day. And so you're going to be, if you're not talking about taking a secured interest in a piece of real property, then you're really in all other cases talking about a security agreement to cover that personal property.
Correct. And sometimes the personal property will be attached to the real estate. For example, solar panels. A solar company comes in, they sell you the solar panels and they attach them to the real estate. If you borrow from the solar company or create a loan to purchase those solar panels, or even you lease them, you're going to give the solar company a lien interest in the panels, even though it appears that they're part of the real estate now. They're not. They have a lien against that personal property. If you don't pay, they could go onto your roof and remove the solar panels from your roof and repossess them.
Yeah, or this one, my favorite, the manufactured or mobile home on real estate that hasn't been affixed to the property. You've got real estate and you've got personal property, and both are liened differently.
Correct.
Both are conveyed differently.
Right.
I can't list how many times we've seen that mix up.
Right.
And so yeah, important to note, it's a lot like a mortgage with real estate, but it involves personal property. Thank you for that, Sean. So we're going to get into some news that we have for NREM to talk about a couple of events coming up. The first one is the Creative Finance Symposium. That is taking place this Thursday, February 23rd, taking place from 6 to 7. Sean, why don't you give our listeners an idea about what the Creative Finance Symposium is?
Yeah, so the Creative Finance Symposium is a different format than this podcast. It's presented by NREM and it will be hosted by Andy and myself. But basically, it's an opportunity for us to do a deep dive into creative finance over a period of time. So this Thursday's our kickoff. We will be basically doing symposiums every other Thursday with different topics. So this week's topic is the different structures for creative finance. But it's all things creative finance. And we're not going to have guests on or anything like that. It's just, the two of us discussing creative finance. And what's cool about this is we're going to do a little presentation on the topic for a half an hour at the beginning. And then the last 30 minutes, we are going to open it up for just an open conversation. That's, kind of a symposium. That's kind of what it is, right? Is the idea of gathering together and discussing a particular topic. So we're going to open things up for an open discussion on all things creative finance. So it doesn't even have to relate to the topic, for example, this case structures. It doesn't have to relate to that. It could be anything creative finance that you want to discuss, that whoever's in attendance wants to discuss. They can put out a topic. They can ask a question. We'll do our best to answer it and give some guidance there. But it's really just kind of more of an open forum with a little bit of formal format at the beginning where we have a PowerPoint, talk about a topic, and then we open it up the last 30 minutes. And it's only for those that register and attend. This isn't being broadcast live. It's through a webinar software that you have to register and actually be present at the symposium in order to participate and gain the knowledge. We're not, at this point, we have no plans to publish in total the symposium. We're not going to make it available for those that don't attend. So either you're there or you miss it. We're not, we might have some clips and stuff here or there, but it's not going to be where we publish it and say, yeah, you can sit down for an hour and watch it, even though you weren't able to attend live. It's completely live, and that's how you attend. It's free, but you have to be there live and to participate, attend, and obtain the information.
Yeah, so make sure to be there live. There is no opportunity for you to say, well, I'm going to sit this one out and just watch it later. If you got things to address and want to be a part of it, you got to be there live, and look forward to having you. Also, coming up here is the Buy and Hold meetup, and that is next Tuesday, February 28th, starting at 4:00 p.m. Like always, is live at the Scottsdale Area Association of Realtors. We'll be live streaming there prior to the event, beginning at 4:00. The event starts at 5:00. Sean, why don't you tell us a little bit about who's presenting at this Buy and Hold meetup?
Yeah, so we'll be there live starting at 4:00, and then around 5:15 we have presentations. So I was fortunate enough to be asked to be on the panel this coming Tuesday. So a week from today, I will be one of the presenters, along with Eileen Brown from American Title Service Agency. And she's a branch manager and escrow agent with them. And we're going to be discussing creative finance. So Eileen's, an experienced escrow agent dealing with creative finance transactions, in particular, subject to and wraps. And then I'm going to be addressing things from the legal side of things for creative finance. And once again, we'll probably do a deep dive into subject to and wrap transactions. And so it's going to be a panel discussion, nothing formally prepared, just more of questions from the moderator and the audience that we're going to answer there. But it should be great. I mean, creative finance, in my view, is something that really needs to be in the tool belt of investors and even real estate agents. And I know a lot of real estate agents attend. They really need to understand this, because there are properties out there that are difficult to sell or even unsellable for various reasons. Even the fact that they might be slightly upside down and you would have to do a short sell otherwise, but you could probably sell them by creative finance if you're a real estate agent, and obtain a commission if you structure it the right way. And so we'll go over those things at the Buy and Hold. We'll go over those types of things in the Creative Finance Symposium as well. So there's going to be a lot. INRIM's going to be doing a lot with creative finance coming up. So, you're not going to want to miss that.
All right. Creative Finance Symposium and the Buy and Hold meetup. Make sure to be a part of both of those if you can. So we're also taking questions today at the end of our episode. We're setting aside, like each episode now, the last 15 minutes of our show to really address any questions that you, the listeners, have. So Mayu, why don't you give our listeners an idea about how they can go about posting questions?
Yeah. All right. So if you guys are watching us and you're live with us today, thanks for joining us. Like Andy said, we are taking questions. So about 10 to 15 minutes at the end of the show, we'll be addressing any questions. If you are watching from our YouTube or Facebook, you can just post in the live chat. We are monitoring the comments, so we'll answer them at the end of the show.
Awesome. Thank you for that. Make sure to post your questions and comments. With that, we're going to go ahead and get into the substance of the show, what we're talking about. And we're talking about estate planning for real estate investors. Now, this is a show for real estate investors, but a lot of this estate planning discussion really can and does apply to all forms of business owners and even non-business owners, and any individual who's looking to protect their assets and looking to protect their beneficiaries, their heirs, so on and so forth, and how to best go about that. So let's get into that. One of the common things I think that I see, and I'll see what you think about this, Sean, but a common misconception I get from clients that I meet about estate planning is that they confuse it with asset planning or asset protection and business planning. They come in and they say, "Hey, I need you to do a trust for me, and so that's so nobody can sue me and take my assets." And that sounds good. That's what a trust does, right? And and then the discussion is, no, there's a different process for that. Sometimes they go hand in hand, sometimes they don't. But in starting this, how do we differentiate, in your mind, Sean, asset and business planning from estate planning for the real estate investor?
Yeah, and I agree. That is a common misconception. I need to form a trust because I need to protect these assets. No, that's not how this works generally. There are asset planning techniques that can be used, for high end estate planning, using irrevocable trusts and things like that. But that's not your basic estate planning. Most individuals just need a basic estate plan. And what a basic estate plan means is that you're going to create a revocable trust. So a trust that can be changed and amended, assets can be put in and pulled out of the trust. And it basically is the individuals who create the trust. We call them settlers or grantors. So the individuals that create the trust, it's still their assets, basically. And it's one and the same. And the law treats it as one and the same. So I can't go and create a revocable trust and then put all of my assets in the revocable trust, take on a bunch of debts in my name, and then say, "Oh, sorry, creditor, you can't come after the assets in this trust." No, it doesn't work that way. Basically, the trust and I are from an asset perspective, are one and the same. I can do with those assets whatever I want. Nobody ever is looking over my shoulder. And, those assets are mine, essentially. All I'm doing is creating a trust and putting assets into that trust to avoid probate and to allow somebody to step in and to basically control my assets if something happens to me. Either I become disabled or I die, and somebody's able to step in, control it, and then I can designate who receives those assets if I die. Go ahead.
Yeah, go ahead.
So asset protection and planning is different, because what asset protection and planning is, even business planning, it's probably a better word, is business planning, is you are creating one or more businesses, entities like limited liability companies, corporations. You're creating those, and you're creating a separation between your personal assets and your business assets. And the law dictates when you can use and access the business assets, and as opposed to your personal assets. So the business assets are not one and the same. There are formalities that the law requires that you maintain and keep in order to properly access and utilize those assets. And so you're creating a separation. Asset planning is creating a separation between your personal assets and your business assets. That's asset planning, versus a trust doesn't do that. A trust creates no separation. What's in the trust is mine, and what's mine, is eventually ends up in the trust. And it's one and the same, versus business is not. You're supposed to create that, wall between your personal assets and your business assets, and only use the business assets as the law allows.
And I know we'll get into this in a little bit, but I think a common misconception that I find with clients that are looking into this, they think that the trust is just another form of kind of business ownership in a sense, and they think it's an either or type of option. And in reality, it's not an either or. The two work together, but they hear from lawyers, well, there's this funding process to trust. There's this process where the trust has to own an asset or your assets. So understanding and having a conceptual idea about what that looks like, especially for a real estate investor who might have multiple LLCs and entities owning a variety of different properties. What does that look like? On and so forth. So I think that causes a lot of the confusion.
Yeah, definitely. It's basically a lack of explanation and education with respect to the client, as well as there's a lot out there on the internet where, there's either lawyers that, are trying to sell services that may or may not be needed, or there's individuals out there who claim to be able to assist with, this type of planning when they don't really appreciate or understand exactly what that looks like and how, trusts operate and should be handled and managed as opposed to corporations and limited liability companies.
So let's lay some groundwork here.
Yeah.
For estate planning. No doubt most people listening have heard the term trust. No
Yep.
doubt everybody listening here has heard the word will. But just about every time I come in and meet into a conference room and meet with clients who have decided to take the next step to do estate planning, they say, all right, well, I spoke with some folks and they said, I got to do a trust. They said, it's a lot better than a will. But they don't have any idea or concept of why it's better. What does it do that's different than a will? So let's kind of start from the beginning. What is the difference between a will and just a basic trust?
Yeah. So the main difference is that a trust creates basically it's not really an entity, but a holding mechanism where assets can be put into the name of the trust. And then you don't have to go through probate. A will requires probate. So a will is, you don't have to retitle your assets. Your assets remain in your individual name. And then your will says, hey, those assets in my individual name, here's who's going to receive them. Versus a trust says, oh, those assets held in this trust, they go to this person. So that's the difference, is a will keeps the assets in your name and then defines who's going to receive your assets, versus a trust defines who receives the assets in the trust as opposed to in your personal name. Now, a trust doesn't require probate. A will's going to require probate. A trust protects or defines successor trustees in the event of incapacity. A will does not. A will cannot be used for that purpose. You would have to have a separate power of attorney that would deal with assets still in your name and your incapacity. Now, some of the similarities, they both appoint who takes control of your assets should you die. They both identify somebody for that. The only difference is in a trust, the trustee can step in tomorrow and take over the assets and the affairs of the trust, versus in a will scenario, what we call in Arizona personal representative, some states call it executor, that individual will actually have to go to probate court and be appointed by the probate court, which, depending on the type of probate here in Arizona, we could get somebody appointed as quickly as a week and a half, maybe even a week if it's an emergency. And it's an informal probate. If it has to go formal, which is, court supervision of the probate, then, it could take 30 days to even 60 days before somebody's appointed. The other similarities are both of these documents allow you to designate who receives your assets should you die. So the designated beneficiaries, and they're both of them have beneficiaries. So who's the beneficiaries of the trust and who's the beneficiaries of the will? And you can do mostly the same things. I think there's a little bit more wiggle room on a trust as far as, some creative planning, versus a will is a little bit more rigid as far as, what you can do as far as like minors and things like that. And then lastly, a will is what you use. You can also put in the trust, but a will is really what you use for your guardianship designation should you have minor children. So you would put that in your will and say, here's who I appoint to, be in charge of and be guardians of my children, my minor children, if something can happen to me. Now a trust has better provisions that you can add for the inheritance by minor children. Trust you can put in there and say, hey, look, if I have minors, we're going to hold this money in trust. My successor trustee, the person that takes over for me, they're allowed to, spend money on this, and they don't have to go into court and ask for permission from the court every time that they want to do that. And then they can provide the balance of that trust to the minor at set times, right? So it could be, give them 50% when they turn 25 and the remainder when they turn 30, or, basically you can be as creative as you want there. Versus a will, if a minor's going to inherit under a will, it's going to be placed on deposit with the court. And anytime you want to access it, you're going to have to go into the probate court and say, Judge, the minor needs a new laptop for school. Can we do that? Oh yeah, you can do that. Or the minor needs tuition. Can we do that? Yes. You have to ask the court's permission. And then when the minor turns 18, the balance is just given to the minor, which most people don't want. I mean, most 18-year-olds aren't going to have any ability to manage any sizable amount of money. It'll be gone pretty quick, I imagine, for most 18-year-olds. But so
it'll be a cool car.
It'll be cool, man. Yeah, it'll be a cool car. That's exactly what you're right. That's exactly what they'll spend it on, those are the kind of the main differences. Cost wise, you either pay now or you pay later. A lot of people think, probate's so expensive. Not always. If you do an informal probate with, no court supervision, you're able to do that. It's not much more expensive than putting an estate plan in place. So cost wise, you pay now or you pay later. The key is, how difficult are you going to make it for, the people after you to deal with your affairs? A trust makes it easier. I mean, that's the bottom line. It really does. But
yeah, a trust makes it kind of depends on what point of the process do you want it to be easier. So if
Right.
you're really concerned about your heirs and simplifying things for them at the point of your death, then the trust is the better vehicle, because I don't have to worry about probate. A successor trustee steps in right away with the documents. Bing, bang, boom. They're going and they're sailing. On the flip side, there's this process when we create a trust of having to fund the trust on the front end, which is to place title of the assets of your assets in the ownership of the trust. I like to tell clients, I'd like to think that I can create the best trust that you've ever seen. But even if I do that, if you don't put your assets in the name of this trust really doesn't do what you're wanting it to do. Now, there's protective devices that'll make sure the assets ultimately make it to your trust, but you're going to be in probate and you're not going to be doing what you were hoping to do. So there's this process on the front end, and it certainly can be a process of funding the trust. Whereas if I were to have just done a will, I can basically end it there, because if Andy Fowler makes a will and I die, then all of those assets in the name of Andy Fowler are going to get grabbed by that will. Now they'll have to go through probate, but so it's kind of like, do you want to do the work on the front end, a little bit of work on the front end, or do you want to do the work on the back end?
Yeah, that's exactly right. Do you and same with the expense? Do you want the expense on the front end or do you want it on the back end? Because either way, you're paying for it. It's coming out of your estate one way or the other. So just whether now or later.
Right. I think as a general rule, the consensus usually is that the trust is the better vehicle. If you're really putting the time and planning into it, is the better vehicle. Now, what people need to understand, that when you do a trust on the front end, there's a little bit more paperwork, because you're still doing a last will and testament for the individual that are the grantors and settlers of the trust. You're still doing a last will and testament for them as basically a backup. Why don't you explain for the listeners why we do that?
Yeah, so that's called a pour over will. So it's basically, as the term indicates, everything pours over into the trust. So it's a backup. Basically says, hey, to the extent that there's an asset still out there in my name, then it goes to the trust. The trust is the beneficiary of the pour over will. Everything pours over into the trust. Couple of points on that, though, is number one, if the value of the asset still in your name exceed, I believe it's 100,000 here in Arizona anyway. If they exceed that amount, then you're going to have to do a probate, and you're going to have to appoint a personal representative, and then the personal representative will be empowered to move those assets from your individual name into the trust. If it's less than 100 and subject to financial institution approval and requirements, you possibly can transfer those assets by way of affidavit. But yeah, it's a pour over will. It pours over into the trust. It names the trust as a beneficiary, and then generally names your successor trustee as personal representative or executor with tasked with the job of moving assets held in your personal name to the trust.
So that's why if you fail to do the funding mechanism part of a trust, your trust is still going to eventually get the assets because you've done the pour over will and made your trust the beneficiary. Let's get into types of trusts. So what are I know we've got the irrevocable living trust and essentially revocable trust. I think trust could probably be broken down generally as to irrevocable or revocable. Do you agree?
Yeah, there's also charitable trusts, that can be done. And that's real high end estate planning of like, hey, how can I give money to this charity and create this trust and lower my overall taxable estate so that it's below the state tax or the estate tax exemption amount, which the federal amount is, I think, over 10 million right now, obviously subject to change. But nevertheless, that's more of a high end. But yeah, you generally, that falls into revocable and irrevocable are the two types of trust that most people are looking to create.
Yeah, and I think, 80%, 80 to 90% of probably estate planning happens with an irrevocable trust. I'm sorry, a
Yeah,
revocable
I
living
always get
trust
those mixed up too.
vehicle.
Yeah.
Yeah, so a revocable living trust vehicle that allows for you, the grantor or the settler, the ability to revoke, to change, to amend, to terminate, to do all of those things. It gives you a lot of freedom. So that is probably the most common type of trust. What are the scenarios and situations where you've seen or where somebody might run into doing an irrevocable trust, a trust that by definition can't be changed absent maybe a court order to allow it?
Yeah. So basically, there's three purposes that I've seen for an irrevocable trust. One is asset planning. Hey, look, I want to create a separate entity. So an irrevocable trust, you actually obtain, and for it to be viable, you have to obtain a EIN. It has to have its own tax identification number. You don't just use the grantor or settler social security number. It's an actual separate EIN, which then allows you to treat it as its own like operating entity. So that's one. You can do it for asset protection, but in my view, it's cumbersome. An LLC, you do articles of amendment tomorrow and you have a new owner of the LLC. It's not that simple with an irrevocable trust. In fact, that's the term. It's irrevocable. It means there's very limited things you can do to change it. Second is estate tax exemption planning. There are certain amounts that can be put in to an irrevocable trust to lower the estate tax exemption or lower the amount in the estate for purposes of estate taxes so that you can hopefully have better access to that estate tax exemption. And then third is like long-term care planning. You can put a certain amount in, and I don't know the ins and outs of this because we don't do what they call here in Arizona access planning. I don't do that. There are firms that, that's all they do. Or it's a major portion of their practice. I don't do that. So I don't know the exact dollar amounts, but you can use an irrevocable trust to put some assets in to basically lower your assets so that if you ever need like long-term care provided by the state won't be able to pursue or go after those assets. But it requires advanced planning. You can't just all of a sudden wake up, and like, oh, shoot, I need to be in the hospital long-term. Transfer everything out of my name. It doesn't work that way. It has to be a planning process. And all of this generally is long-term planning. And, for this type of planning, people generally spend, $20, $30, $40,000, but it's going to save millions of dollars in taxes or millions of dollars in protection from, for long-term care and things like that. So they're willing to do that for the savings and benefits. But most people, like you said, don't need to do this type of high-end planning. A revocable trust, along with some business planning like LLC formations, corporations, that type of thing, are more than sufficient to accomplish both the estate planning objectives and asset planning or business planning objectives of most investors or individuals.
Now, we have no doubt some people watching, because this is a real estate show, that are thinking, now Andy and Sean have forgotten about a very important trust out there called the land trust. So let's talk about the land trust and whether it's a different type of trust or the same kind of trust. At the end of the day, we did an entire episode, which we'd encourage everybody to go watch, with a guest, William Bronchick, from attorney out of Colorado, who does a lot with land trust and knows more about them than the rest of us can remember about them. So at the end of the day, though, is a land trust really any different? And how is it different, if it is, from a revocable living trust?
So there's a few things that to talk about with the land trust. So first, to answer your question, it is a revocable living trust. So an individual can have multiple revocable living trusts. They can have as many as they want. The key is, what assets are they putting into those respective, trusts, and why are they using them? But a land trust is a revocable living trust. So from an asset protection standpoint, it doesn't provide any. So if you put a piece of real estate in a revocable living trust or a land trust, and there's liability there, that liability flows through to the settlers or grantors of the trust. And likewise, if the settlers or grantors of the trust end up with liability, it flows through to the land trust. There is some utility for land trusts. The first is, it can create anonymity. So you basically give the land trust an anonymous name, and like you can call it the in-rim trust, for example. Like, who's in rim? Like, why? So nobody knows that it's an individual's trust, and you call it the in-rim trust. So you give it an anonymous name, and then from there, you can swap out the beneficiaries of the trust, the trustees of the trust, by a simple amendment. And so you can change ownership behind the scenes without having to record the amendment or anything like that. The only time you would need that amendment is if you go to sell the land or the property that's holding the trust or that the trust holds. And then you show that to the title company, and they say, oh yeah, I see who the current trustees are. They're authorized to sell it. And then I see who the beneficiaries are. They're authorized to receive, payment. And it goes from there. So that's one utility of a land trust. The problem with that is, not every state allows for that level of anonymity. So in Arizona, it doesn't work. And so we don't do really many land trusts here in Arizona, because of the fact that when you create that land trust, and that land trust is going to own property, the deed must, for it to be enforceable, for it to be a valid deed, a valid conveyance of the property, the deed must list the name and address of all beneficiaries of that land trust. So if I go and I create a land trust to try to, be behind the scenes, well, that doesn't work, because my name and address is going to be right there on the deed as the beneficiary of the land trust, right? So anonymity is kind of out the window here in Arizona. Now, with that said, I have created and worked with clients to create, I don't call it a land trust, I call it a real estate holding trust. And I've created it not for purposes of anonymity or asset protection, but I've created it for purposes of planning. And, an example of that could be, hey, look, I have property that I want to provide a life estate, for example. I have a relative that's living in this property. I want to make sure that that relative can live there for the rest of their days. And I don't want anyone coming in and kicking them out. So I don't want my successor trustee coming in and kicking them out. I want them to live there. But I don't want them to inherit. I have other plans for who inherits that property. So in that case, maybe I create a trust that's separate from my revocable trust that I then, make so that my relatives can live there. Maybe appoint them as successor trustees so it can remain in the trust, and then they can, operate the property and deal with the property. But my beneficiaries are going to be different. My beneficiaries will be someone who I designate. And so I put it in the trust to basically create that life estate and create, an order for functioning, for that property functioning after I pass away. And so I create a real estate holding trust for that purpose. So yeah, land trusts are out there. My preference for asset planning is using LLCs. LLCs can be amended just as easily, in my view, as a land trust. Now, the amendments may or may not be public. For example, Wyoming or Delaware LLCs, I can go amend the operating agreement tomorrow, and it's not a public document. Nobody knows that it's been amended, so I could change ownership. So I could, set up a Wyoming LLC, have it own an Arizona LLC, and then have that Arizona LLC own the real estate. And then all I have to do to change ownership really is swap out the operating agreement or amend the operating agreement, which is, generally a one-page amendment that's real quick and easy. Don't have to file it with anybody. Doesn't cost anything other than if you hire our office, a small amount of fees, or you can do it yourself. You amend the operating agreement, have it executed, and boom, you've changed the ownership of the property. So that's my preference for structuring it. It costs about the same. Well, it does cost a little bit more to start that Wyoming holding company. But at the end of the day, I think it creates a better level of protection because you're dealing with LLCs as opposed to trusts, which are, once again, a revocable trust is not an asset planning vehicle or asset protection vehicle.
So let's talk about the documents that the listener should expect to comprise a typical estate plan. And we've talked about a few of them: the trust, the revocable trust, or whatever type of trust that it might be, but probably going to be a revocable living trust. A pour-over will. You're going to have the pour-over will to be there to protect, to be a backup, to ensure that if any asset was not titled in the name of the trust is going to be grabbed by that pour-over will and given back to the trust as a listed beneficiary under the pour-over will. What about financial powers of attorney?
Mm-hmm.
That's going to be a document as well, and I think this is an important document, but an often overlooked document because on one hand, the thought is, well, okay, why do I need it? I've got the trust. I've appointed trustees and successor trustees, but a lot of times, I think people in thinking through estate planning are thinking about what happens after they die and forget to think about what happens before I die. Because there are circumstances where you might need somebody's help before you die, that where a will doesn't yet kick in or a trust doesn't necessarily contemplate, depending on some of its provisions, until you've died. So talk a little bit about why a financial power of attorney is important. I think it's probably worth discussing too, that one of the reasons it's important is if you fail to do it, the potential need for the appointment of a guardian or a conservator and what that legally looks like and how much that could potentially cost you, right?
Yeah, so you're right. This is an important document, and if the property's held in the trust, then the trust has provisions on incapacity and the successor trustees taking over and that type of thing. However, where the power of attorney kicks in is when you don't title property into the trust and you keep it in your individual name, and then something happens and you're not able to manage your own affairs. Where we've seen this go really bad and really south is, and this situation has happened over and over. Husband and wife, they take title to the property, community property with right of survivorship. Everything seems great. That's a good way to title their marital estate. And they decide, oh, it's time to sell the property. Well, unbeknownst to the buyer and maybe even the agents, the husband has dementia. Well, title company learns of it. Well, title company's not closing that transaction.
It's too late.
Too late. Title company's not closing that transaction. They're going to say, nope, where's the power of attorney? Well, we don't have a power of attorney. All right. Well, you're going to have to go into court and you're going to have to be appointed conservator of your spouse. And you think, oh, well, what's the big deal? I'm the husband, or I'm the wife, not a big deal. I'm going to go get appointed as conservator over the husband. Okay. Well, that's good and all, except by statute, at least here in Arizona, not only do you don't have to have an attorney, but there's no way you're going to be appointed as a conservator without an attorney. It's a very complicated process, honestly. It's one of the more complicated probate processes here in Arizona because you have to actually secure medical opinions, introduce testimony and evidence for that appointment. And so it's more than just filing some paper, filling out some blank forms and submitting them to the court. I mean, there's things that have to be done. So you're going to have to hire an attorney. And guess what? By law, the court is going to appoint an attorney for the spouse who you're seeking to obtain control over. Well, that attorney doesn't work for free. The court appoints them, but the state doesn't write them a check. Instead, they look to the marital estate or the marital community and for payment of their money. And so now you have two attorneys that are working to have this appointed, and you can do it expedited, but it's not like, hey, expedited tomorrow type thing. Because, the appointed attorney has to meet, you have to get the medical records, you have to do all of this. You're talking at least at the soonest a couple of weeks, if not a month. And that's expedited. Long story short, it's, tens of thousands of dollars to go through this process when a simple, $500 power of attorney would have solved the problem. And it's a major problem. It delays closing, that type of thing. And we've seen this repeat itself over and over and over again. And you think, oh, what's the big deal? We're married. It should be simple. No. Once a spouse has some type of, mental issue, physical issue that doesn't allow them to transact, all of a sudden, this whole new process kicks in that's very expensive and time consuming.
So much about estate planning is about authority.
Mm-hmm.
Everybody thinks it's about who you're going to give your stuff to when you die. And that is a part of it. But too many people don't realize that what this process is really dealing with is how can we take your assets that have your name all over them, your bank accounts, you name it, has your name on it. How can we then convey those, sell those, lend upon those, do things that you would normally do once you lose capacity to be able to do it? And eventually it's going to happen, whether it happens while you're living or whether it happens at the moment of your death. The fact of the matter is your assets don't change. They still have your name, John Doe, on this piece of real estate, and John Doe is still going to have to sign to convey this real estate. So much of this process is how do we establish who has the authority to now sign on behalf of John Doe? And unless you have thought through it and intentionally assigned that or have named those persons, the only other source that's going to do it is a court-appointed person. And like it or not, when you're dealing with the courts, you're dealing with judicial calendars, the appointment of other lawyers, due process, the allowance of time to happen. And it's just not going to happen. It's just not going to happen quick. Before we get into the other documents that kind of make up part of the estate plan, we're in that kind of 15-minute window. And I know we have a few questions that have been posted already. So I'm going to turn it over to Mayu And if you will, give us some of the questions we have.
Yeah, so we still only have a couple right now. It's not addressed to anyone in general. You guys might have briefly discussed it a little earlier when you were talking about asset protection. First question, if you have a significant other and you both own properties in two different LLCs, can you just have a holding company, these two LLCs, and still be protected without going through a lot of changes to the LLC and or properties?
Sean, we'll let you address that one.
Yeah, so that's more business planning than it is estate planning. With that said, it's pretty easy to change the ownership interest of LLCs. So yes, you can form a holding company, and then that holding company can pretty easily become the member through articles of amendment of the lower level LLCs. Couple of things to think about though would be, who's going to be the owner of the holding company? What's the percentage of ownership of that holding company? Is it going to be, the husband and wife, 50-50, that type of thing? Second would be, why were the LLCs owned separately? Is that sole and separate property that now you're commingling as community? So that's something to think about. And then finally is taxes. You want to make sure that you seek the advice as a CPA of, well, what happens when this holding company with, different ownership with, the married couple owning it, does that, impact or create a taxable event? How should the holding company be taxed? Should it continue to be taxed as a sole proprietorship or as a partnership? All of those questions should be addressed by a CPA. But to answer the question is, it's pretty straightforward to form a holding company and then change the ownership of those lower level LLCs.
All right, Mayu, what was our second question?
All right, second question. If you run, let's say, 2 to 3 businesses out of your primary residence, should you sell your property to your LLC and rent it back?
Sean, what do you think?
No,
You look skeptical.
never. Absolutely not. So most states, including Arizona, have very strong homestead protections. And those homesteads only apply if the property is held in the name of an individual or their revocable, not irrevocable, but their revocable trust. The homestead exemption goes away if ownership is named in the LLC. And generally, the homestead protection is going to provide greater protection than what you can obtain through an entity like an LLC. So the answer is no. Now, talk to a CPA about your ability to claim portions of your property that you use for business as, a write-off, for lack of a better word, but what's it called? An exemption or a credit or something, something on your taxes. What's it called, Andy, where you claim something on your taxes that lowers your income? Exemption, I think, is what it is.
Or deduction.
Deduction. There you go. That's the term I was looking for. So you can claim it as a deduction on your taxes, a certain percentage of your home. So if you use, you have designated rooms and you use, 50% of the square foot of your house, talk to your CPA. But there is a chance, I'm not a CPA, I'm not a tax attorney, but there's a chance that you could probably write off 50% of, the expenses related to your property, or have a deduction for that amount. But consult with a CPA. But from an asset protection standpoint, I never recommend transferring primary residences out of the individual names.
So additional documents, jumping back into our discussion before, that make up and comprise a typical estate plan also include, in addition to the financial power of attorney, is also the healthcare power of attorney. And that is your opportunity to identify an agent who's going to be there to make healthcare decisions, who the doctors can look to in the event that you're not able to make those decisions, can handle that. Different from the financial piece of things, this might be the same agent and it might be an entirely different person. Oftentimes I find in estate plans, individuals who somebody might look to for making important financial decisions is not the same person who they might look to make important health or medical decisions. In addition to healthcare directives, asset transfer documents are an important piece of the estate plan that includes a trust. And so I want to talk about here, with the little bit of time we have left in the show, that piece of asset transfer documents. So kind of two parts to this. How should assets be titled into a trust? Because we talk about this funding process that has to happen. What should that look like? But let's add on to this discussion the second layer of how do you do that when you're also a business owner, when you also own, maybe like a lot of the real estate investors watching the show, they've got multiple businesses or multiple limited liability companies or corporations that they're dealing with. What does that look like when we tell them, look, all of your assets need to go into the trust? And they think, well, wait a minute, you just set up this complex, uh, corporate holding structure. How is this supposed to work together? So what is the answer? How should assets be titled, and how do you work through the titling of assets in a trust, as well as limited liability companies and other types of business interests?
So your primary residence, so when you do an estate plan, your primary residence should be transferred by warranty deed into the name of the trust and maintained that way. Your bank accounts should be transferred from your individual name into the name of the trust. Your mutual fund account should be transferred from your individual name into the name of the trust. There's different issues that have to be addressed at times with life insurance, with retirement accounts. We won't go into there. Those are something to talk with your financial advisors, your attorney, your CPA on. But business assets. So what to do with the business? So the basic business structure that I like to see, whether you want anonymity or you just want to create a basic business structure, is to have a holding company, a holding limited liability company that's either a Wyoming or Delaware company, or if you don't really care about anonymity, it can be in Arizona or whatever state you're in. It can be the holding company. And the owner of that holding company is the trust. That's who the member is. The sole member is the trust. And then the managers, so it's a manager managed limited liability company. The managers are the individuals behind the trust. So the individuals that created the trust, what we call the settlers or grantors, they would be the managers of the holding company. That way, when you sign documents, you don't have to disclose the name of the trust. You don't have to say, oh, the so-and-so trust member, so-and-so as trustees. You don't have to do any of that. You simply sign documents as manager. They don't know whether you own it or not. Somebody might assume or presume that you own it. Bottom line is you're still only signing as manager of the entity. Then from there, below that holding company, you have the LLCs that do business, right? That either hold real estate or do business. So you would form an Arizona LLC with the holding company it would be a member managed. So only the holding company would be the member of that company. So it would own that company. And then you have another that owns another piece of real estate. And so you would have an LLC and the member is the holding company. That way, everything flows up to the trust. So everything flows up to the trust from all the way down. And that's what I like to see. I like to see the trust be the owner of the empire, if you will, at the top of the empire, and then everything flow down from there. And so when you think about if somebody were to pass away, how do all those assets flow? And you can really see how they just flow up all the way through into the trust. That's what I like to see from a business or asset planning perspective.
Yeah, I always get the question, and I realize that more thoughtful analysis needs to go in the description when I get from the client, all right, do I transfer the business bank accounts into the trust? And it's like, no, the LLC is going to continue owning everything that it owns. And then going back to our discussion at the beginning, personal property versus real property. We're talking about a personal property interest that this trust is going to own, mainly that membership interest or that maybe a stock interest, depending on what kind of company it is at the top. So good information with that. That is our show on estate planning. There is a lot more to estate planning than that, but this is a good 30,000 foot view of the things that you should be looking out as a real estate investor who hasn't planned your estate planning process. It doesn't have to be that difficult to do. So make sure to join us next week. We're going to be talking about a similar topic, which is business strategies for real estate investors. So we're going to be talking really more about some of the asset planning and some of the other information that's somewhat related to estate planning, but really a different question at the end of the day. So make sure to join us next week for that episode. Look forward to seeing you then. With that, we'll see you guys next week.
Have a good day, everyone.